Orders, Government Bills, Commons, consideration at second reading of Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act.
Ms. Bennett for Mr. Lametti, seconded by Ms. Haidu, moves that Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act, be now read a third time and do pass. Debate. The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General of Canada.
Thank you, Mr. Speaker, and it's really good to see you back in your seat. And I appreciate the opportunity to speak on Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act, which proposes to consider alternatives to incarceration in appropriate cases while reducing recidivism and keeping society safe. Madame la Présidente, je suis heureux.
Madam Speaker, I am very pleased to rise today to speak about Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. It offers possible solutions to the incarceration rate and tries to reduce recidivism and protect society.
To acknowledge that I'm speaking to you on the traditional unceded lands of the Algonquin people. Bill C-5, Madam Speaker, is an important step forward in addressing systemic racism and discrimination. It puts forth an approach that promotes fair sentencing, outcomes for everyone, and notably Indigenous peoples, Black persons, and members of marginalized communities who are disproportionately negatively impacted by inflexible sentencing laws. These changes would continue to denounce and hold offenders accountable. The bill advances three...
I'm not sure if the honourable member's phone is on the desk or something. We keep hearing a little tick, and I think that it would affect the interpreters. So I really appreciate that. The honourable Parliamentary Secretary.
The bill advances three broad categories of reforms, and I will speak on these specifics later on. But I want to speak today about what it means to be incarcerated, Madam Speaker. I know that the conservative approach to crime is about locking people up and throwing away the key. The reality is that many jurisdictions where this was tried have realized its innate failures. But I want to note that Newt Gingrich, one of the early proponents of mandatory minimum penalties, has now recanted and has suggested that mandatory minimum penalties do not work. And all across the United States, this realization is coming into the public discourse. Incarceration is not the answer to all people. There's a need for us to use incarceration only for crimes that are of a serious nature and one that poses risk to individuals. We need to provide off-ramps, Madam Speaker. Systemic racism in the criminal justice system is real. While we may think that our justice system is blind, the outcomes tell us a different story. Indigenous and Black Canadians who go to prison are treated differently. That is, they are mistreated. Their lives are devalued, and for anyone who still doubts that, I invite them to look at the latest Auditor General's report on our correctional system. And I want to give you some snippets of her findings. For example, Indigenous and Black offenders faced greater barriers to a safe and gradual reintegration into society than other incarcerated groups. The process of assigning security classifications, including the use of the custody rating scale and frequent overrides of the scale by correction staff, results in disproportionately higher numbers of Indigenous and Black offenders being placed in maximum security institutions. We noted that Indigenous, and I'm quoting here, that Indigenous representation gaps among correctional officers across institutions, Black representation gaps among program and parole officers at institutions with a high number of Black offenders, and gender representation gaps among correctional officers at women's institutions. Indigenous and Black offenders, for example, were placed at a higher security level on admission into custody at twice the average rate of other offenders. Indigenous and Black men were placed at maximum security institutions at twice the rate of other offenders and made up 51% of maximum security placements. We also found, and this is the Auditor General again, that Indigenous women were placed at a maximum security at more than 3 times the rate of non-Indigenous women and made up almost 70% of maximum security placements. Correction staff overrode, which means that once a classification is completed, correctional staff have the discretion at times to override the classifications. And in this case, correctional staff overrode up to 53% of minimum security placements compared to 27% for non-Indigenous women. So for Indigenous women, they were classified upwards by 53%, while the average was 27% for non-Indigenous women. For Indigenous men, correctional staff overrode up to 46% of minimum security placements to higher levels compared to 33% for non-Indigenous offenders. More Indigenous offenders remain in custody until their statutory release and were released directly into the community from higher levels of security, which essentially means that once somebody is classified, the higher the security classification, the harder it is for them to get the programs of support necessary for them to reintegrate into society. But it also means that they serve a longer period of sentence in custody, while those who may be classified at lower rates or at the lower levels are able to spend less time in custody and more time in bridging programs that will allow them to integrate within the community, which essentially leads, Madam Speaker, to higher levels of recidivism. And for me, the most profound thing about the Auditor General's report is that for the first time, it has quantified systemic racism within our criminal justice system. And I think it's a very important takeaway for us as we look at reducing mandatory minimum penalties. I think it's a very important takeaway for us to reflect on what this means, because we know that the offenses that are subject today of C-5, where we are repealing many of the mandatory minimum penalties, they directly have an impact on Indigenous and Black offenders, and it's so critical that we keep that in mind as we look at this bill. I do want to talk about my personal experience working with young people in the criminal justice system. I used to run an organization called the Canadian Tamil Youth Development Center back in the late 90s, early 2000, before going to law school. And I can tell you I dealt with a number of young people who were involved in the criminal justice system, whether as young offenders or even young adult offenders. I was able to work with them for many years, and I still continue to call many of those young people my friends because of the relationship that we were able to build during that time. Some of these young people were involved in violence. Some of them were involved in very petty type of theft or other mishaps within the community. But what I realized during that time, Madam Speaker, is that they needed support. It was very easy for us as a society to actually incarcerate someone. It is the easiest thing we could do. But the harder thing for us is to support young people as they redeem and as they come out and reintegrate within society. So one of the things that I realized is that the more support that we're able to give young people, the more off-ramps that we provide to those who may engage for the first time or sometimes even the second time in the criminal justice system, the better off society is in the long term. Because I have seen consistently the number of times these young people have been able to come out of the system and are now very active and contributing members of our society. And that's not always the case, but I can tell you the vast majority of the people that I've dealt with, have worked with, that continues to be what I've seen. During the deliberations at committee, we heard from a number of very important stakeholders, and I want to highlight the testimony of Raphael Techi, who is the president of the Canadian Association of Black Lawyers, who obviously support the repeal of many of the mandatory minimum penalties that are here. But he spoke about what his lived experience was as a young black man growing up in British Columbia. And he talked about the time when, for the first time, he was at a theater, and there was some commotion going on outside of the theater, at a movie theater, and he was there on a date, and what he found was that many other young black men were surrounded by police and were essentially questioned. And luckily for him, he had a great support system that allowed him to really defend himself, because he did nothing wrong. But in reality, for many, there is over-policing that oftentimes lead to arrest and subsequently convictions. Because once you're within the cycle of the criminal justice system, it oftentimes just perpetuates. It doesn't. The safeguards are limited. What Mr. Techi, when he spoke, I was able to resonate to my personal life the number of times as someone who's racialized, who grew up in Scarborough, continued to be stopped by the police. And this is not something that's unique to me, Madam Speaker. It's unique to many people who may have grown up in my communities, and randomly stopped and questioned. And this happened even as an MP. It didn't stop even as an MP, or even as a parliamentary secretary, or even as a candidate for the Liberal Party. It continued. But especially for young people, what this means is that oftentimes they're without the right supports, without the right legal advocacy, without parents being able to support them, perhaps because they have multiple jobs, or they have jobs in which they can't take time off. It really does put young people in enormous disadvantage. And I often reflect, as did Mr. Techi, on how life would be when one of those incidents, one of those half a dozen times or a dozen times when I've been pulled over, or I've been subject to this type of inquiry, when that I may have given the wrong answer, I may have been with the wrong people, what my life would be today. And this is the story with so many people within my community of Scarborough Rouge Park, but I know across Canada in many other parts. And it's so profound. And we know, George Floyd happened 2 years ago, and that I think really tells a story of the disparity that we see in the U.S., but George Floyd is not unique. We know the number of times where in Canada, Indigenous men and women are oftentimes just arbitrarily arrested, arbitrarily beaten up. And we've seen it with chiefs, with people who are who have even a national or local profile, where discrimination doesn't really stop with who and what your title is. And we see that with particularly young black men. And last, in 2019, just before the election, or maybe around the election, I remember the Justice Minister, Minister of Justice and Attorney General, the current Minister of Justice and Attorney General, came to my riding as part of his stop in the GTA. And we were able to meet with a whole bunch of stakeholders, most of them who work within our communities with youth. And it was overwhelmingly, the message was that we need to ensure that mandatory minimum penalties need to be addressed. This has disadvantaged many Indigenous and Black Canadians. This is a system that doesn't work. It's a failed policies of the past, and something that we need to absolutely to address it. And one of the people there was Louis March, who many of you may know, is the leader of the Zero Gun Violence movement. And his entire life is in fact been devoted to fighting gun violence, and he was very profound in his in saying that it's a system that does not work. Mandatory penalties, minimum penalties do not work, and he asked that our government address this. So here we are. We are here to repeal all the MMPs for drug offenses, 1 tobacco-related offenses, and 13 firearm-related offenses. And I know when we talk about firearms, when we say we want to reduce the mandatory minimum penalties for firearms, there are many in this House who may legitimately ask, why are we reducing the penalty when use of firearms are on the rise? And it's a question that actually is very pertinent here, because Bill 21 that was introduced by Minister of Public Safety addresses that issue, because what we're doing is we're increasing the maximum penalty for gun-related offenses from 10 to 14 years. But what we're saying is there is a need for judicial discretion, and that's what this bill does. It ensures judicial discretion, but it also gives a discretion to the judge to look at the individual, to look at the circumstances of the case, and increase the penalty for up to 14 years. And I think that's a very important point that sometimes is missed in this debate. Secondly, it would remove certain restrictions preventing a sentencing court from considering the imposition of conditional sentencing orders. And this is a very important issue. It is important to note that once someone goes into the criminal justice system, and I've outlined the issues of systemic racism, particularly as it relates to Indigenous people as well as Black Canadians, that it is an unfair system. It does over-incarcerate, but it does also unfairly miscategorizes people. And what the conditional sentencing orders do here is it allows the judge to impose conditional sentences that may be out of custody on individuals who do not pose a risk to society. And this is a very important point again, because oftentimes, this is not about giving every offender a conditional sentence. It's about smart policy that says when we put someone in jail, in institutions, we criminalize them even further. We don't give them the right supports. We take them away from their families. We take them away from the addiction treatment that they may need. We take them away from their responsibilities of going to work or doing work in the community or doing or being a member of their church or being part of the local community that will give them the support they need to get out of the criminal justice system. It's a very smart policy, and oftentimes it's miscategorized because this is not available to everyone. This is available to those who are deemed to be who do not pose a risk to society. And I think if you look at the numbers over the years, prior to many of these mandatory minimum penalties coming in, there were over 11,000 conditional sentencing orders in Canada. That number is now down to about 6,000. So for those, I know many colleagues who are very progressive will also say, well, this bill doesn't go far enough. And what I can tell them is that this is an important bill because it, in fact, will allow conditional sentencing orders to be expanded in a very smart way that will allow judges the judicial discretion to be able to place individuals who do not pose a risk into paying their debt to society, but at the same time allow them to continue their lives. And this is about 5,000 Canadians as per the statistics that we've seen. And the final part of this is we're looking to encourage alternate approaches at an early stage for responding to persons in possession of illicit drugs. Because we know, and I know the Minister for Mental Health very recently supported the call by British Columbia and allowed British Columbia to take more control over or issues around drugs. But we know that right supports are essential in order to ensure that addictions and mental health are supported, and I think this bill certainly allows that. Unfortunately, Madam Speaker, I don't have sufficient time to complete the speech, but I do want to just emphasize that this is smart public policy, this is smart criminal justice policy, and I look forward to the support of all members here. Thank you, Madam Speaker.